Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. Our first case for the day is Lebron versus State of Florida. You may proceed.
Good morning. My name is J. Edwin Mills, and I represent Jermaine Lebron on his post-conviction proceedings. I know that you've all read the briefs that have been filed in this case. I spoke with Mr. Nunley a couple of weeks ago, and I think we both agree that the issues have been briefed very well at this point. The primary concerns that I have center around two issues, actually, one of which apply to both the guilt and the penalty phase, and that is the cumulative effect of what I believe are errors or omissions that were committed by trial counsel. The second issue I've got deals with only the penalty phase, and that is the 7-to-5 death recommendation when considered along with the cumulative effect of the errors that I believe were made during the penalty phase of this case. I believe as to the guilt phase of this case, as we've briefed, but I want to talk about a couple of things specifically. One is the failure to file a motion to suppress the evidence that was seized out of the vehicle that Mr. Lebron was found in by Detective Rodriguez in New York. That was a day planner that had the victims, it had the victims' identification inside that day planner. I believe
let me ask about the day planner. Now, that was found in an automobile, right?
Correct.
Was that automobile stolen?
I don't recall that it was.
Well, now, if it was stolen, might that not be a significant circumstance? I mean, there may be other problems with your argument, but does someone who has stolen a car have a reasonable expectation of privacy in things that are in the car?
Again, I'm not clear that the vehicle was stolen, but assuming that it was, and I believe that may well have been the case. I don't think that issue, the issue regarding an expectation of privacy in a stolen vehicle, was ever raised anywhere along the line. And
well, maybe because it had no merit.
Counsel would, but you're complaining that counsel did not do something to get that suppressed.
Correct.
Well, but if it's not going to work, then counsel's got no reason to get into it. And I just don't understand how there can be an expectation of privacy in a stolen vehicle. And I know the landscape about searches of vehicles,
yes, sir,
incident to arrest, has changed. That's another issue here. I don't think we can apply that retroactively, I don't think, and say that counsel was deficient then because he could have seen what was going to happen in Gantt. But even putting that aside, even under the law we've got now, I don't see how someone who has stolen a car can have an expectation of privacy in what's in the car.
I don't recall, sir, that there was ever any evidence that the defendant, the appellant in this case, stole that car. In fact, I think that the record shows that he was a passenger in the car and not the driver when Detective Rodriguez came upon the vehicle.
But it was still a stolen car.
That may well be, but I don't know that that necessarily extinguishes his expectation of privacy.
But you
even
do,
if
you do
that's
agree
not-
this happened before the recent change in the automobile search law. This occurred when Belton was still the law of the land.
Well,
The facts in this case.
True enough, sir, but
Okay.
we cited Chimmel in our briefs too, that indicate that a search incident to arrest is limited to the arm's length or the reach of the person that's been arrested.
Which this was in the console, was it not?
I'm sorry, sir?
Was this not in the console? Isn't that the evidence in this case? That
I
they
believe it
found
was,
this?
yes, sir.
So that's an arm's length of any passenger in the car.
Well, I think in Chimmel, sir, that the court talks about at the time the search occurred, and certainly Mr. Lebron and the other two occupants, or at least one of the other occupants, had been secured by law enforcement,
Well, then we have a different interpretation of the Belton law prior to the recent change, because certainly the recent change puts it in that posture. But I think the U.S. Supreme Court has been totally clear that law enforcement is not to suffer the sanction of suppression of evidence when they follow long existing legal precedent, i.e. Belton. I think they even said that, didn't they?
I think you're correct,
Expressly
sir.
said that. So
But I think that my position is that Chimmel also
would still control.
Sir?
Would still control, and
Yes,
you say that controls this case. Okay.
So that
But even if that's the case, don't we have the inevitable discovery rule coming into play here? I mean, this was a stolen vehicle that was going to be impounded at some point because the occupants were under arrest. Certainly, a warrant would have issued to search that vehicle based on the fact that these people were had arrest warrants. And so, isn't it inevitable that this information would have been discovered?
I don't know that was ferreted out during.
But if we think about it, wouldn't that have happened? They would have had probable cause to get a warrant to search that vehicle. The same planner and the shotgun shells would have been found. And so even if we assume that you're correct and that Schemmel and Belton says that you couldn't have searched this vehicle incident to arrest, this same evidence would have inevitably been found.
I don't know, Justice, that there was any indication that you say that we certainly would have had probable cause. I have to respectfully disagree with that. The planner was found inside a console, and
But if you get a search warrant for the vehicle, you could have searched the entire vehicle, including that console. Correct?
Absolutely, you could have. I'm not sure, though, Justice Quince, that you could have gotten a search warrant with the information that law enforcement had at that time, other than the fact that 2 or possibly 3 of the occupants of the vehicle were placed under arrest.
And that the vehicle was stolen. Because the vehicle was stolen, they certainly were not going to even turn it over to anyone, correct? Not the 3, it were 3 occupants of the vehicle,
There
right?
were.
They were not going to turn the vehicle over to any one of those persons, correct?
I think you're correct. Yes, ma'am. Okay. Yes, ma'am. The other issues as to the guilt phase of the case have to do with Mr. Slovis's performance as trial counsel. Now, this case has been up before the Supreme Court a number of times. I'm sure, I know, I'm confident that the court's aware that Mr. Slovis tried the guilt phase of this case by himself. His death penalty qualified counsel was involved in another trial at the time the guilt phase took place, and Judge Perry did not or would not continue the case so that death qualified counsel could be present. Mr. Slovis stated a number of times that he was not qualified to select a jury in a death penalty case, that He had no idea what he was doing. He had never participated in a death penalty case in the state of New York where he was licensed.
But despite that, what was erroneous about his selection of the jury?
I would submit to the court that his jury selection performance was deficient, certainly. Mr. Lebron is a minority, and there was at least one African-American gentleman that was excused without objection by Mr. Slovis, that was excused because of what was characterized as an extreme hardship. He had to take have to take the bus to the court each day, and Mr. Slovis did not attempt. Certainly, he never asked for a Batson inquiry.
No, but we're talking about an ineffective assistance to counsel claim.
Correct.
And so you've got to prove both deficient performance on the part of the counsel and resulting prejudice, correct? And what is the standard in a post-conviction to show prejudice and erroneously allowing a juror to be excused?
I believe that it's proven. I believe the standard is by a preponderance of the evidence. Certainly, Strickland doesn't require that we show that the outcome would have been different. I think Strickland in the cases following Strickland not simply, but require a showing that there is a likelihood before we have met our burden.
I believe, and when we're talking about the erroneous challenge of a juror, don't you have to show in post-conviction that a juror who was subject to challenge actually sat on the jury? Isn't that the standard when we're in post-conviction?
I don't believe that it is. I'm sorry, I have to disagree with that position. Again,
what did the trial judge find about that particular claim in his order? I mean, didn't he make findings and say that basically the counsel had objected, but that there was no authority because this was on a financial burden, that there was one prospective African-American juror.
Correct.
But that there was no authority to have had the state pay for this juror to get extra transportation. So the idea that because this guy, the lawyer's from New York, that somehow that renders his performance deficient when the trial lawyer objected and it was overruled, and I'm not sure what else you would have expected any lawyer, death qualified or not, to have done under those circumstances.
I would certainly expect that there would be further inquiry into the hardship and the.
But that's, now you're getting into we are all familiar with Strickland. The Sixth Amendment requires that counsel perform in a minimally competent way. You're sort of asking that, well, I think he should have done this, I think he should have done that. That's the classic 20/20 hindsight. And so do you you're raising several claims. What would you consider, is this your best guilt phase claim on ineffective assistance of counsel? Is it this one or?
No, it's the culmination of several.
Well, so far we have a motion to suppress that based on inevitable discovery or the fact that the vehicle was stolen that would have been meritless, a objection to a juror not being excused for financial hardship, that there's no case law that would say that juror should have been allowed to sit. What else is there?
Judge, Justice, Mr. Slovis failed to object to various statements that were made by the prosecution during the course of the guilt phase, such as it's the law that you impose death if aggravators outweigh the mitigators. That's certainly not an accurate statement of the law. It's proper to impose death if the aggravators outweigh the mitigators. That may be close to being an accurate statement. He failed to object or move for a mistrial when it was said that it's incumbent to vote for death if the aggravators outweigh the mitigators.
Do you have anything on your guilt phase issues that would point to a question as to whether our confidence in the outcome of this guilt phase, that is, that Mr. LeBron is in fact guilty of first-degree murder, is undermined? Any witnesses that should have been called that weren't called, new witnesses that have been uncovered, a deficient guilt phase investigation, anything of that nature that would call into question the integrity of this verdict?
The witnesses that come to mind in response to the question are Robert and Charlotte Spears.
Well, but they couldn't find those still, even at the hearing on the collateral relief, correct?
That's correct.
So, I mean, this is, I'm not aware of any case in Florida that says that you can say X and Y should have been called as witnesses without presenting X and Y to testify during the collateral proceeding, because if we could do that, we'd just have pure allegations without any evidence. And so here, it seems to me that even if we accept they should have been called as witnesses, there's a failure of proof because there was no evidence during the collateral proceeding. Isn't that correct?
Yes, sir, it is.
Okay.
It is. I mean,
You're in your rebuttal. I have, you had several penalty phase claims, and my question just generally on that is, this was his, fifth penalty phase, Mr. LeBron's, or fourth, third?
I don't think it was his fifth, Your Honor.
Well, he got several 7-5.
He has.
I mean, almost each time, it's sort of remarkable. Mr. Norgard was his lawyer.
Correct.
Now, Mr. Norgard is well known to this court, and we could take judicial notice of the fact that Mr. Norgard testifies frequently for what is deficient in investigation. It is I'm hard-pressed to see how, after Mr. Norgard looked into the mental health mitigation, obtained mental health experts, and got what he thought would be a damning diagnosis, how Mr. Norgard could be faulted for that reasonable trial decision after investigating the mitigation. And I think you just have a very difficult burden on this, especially because it was tried so many times, like to say, well, nope, I think he should have put that mental health expert on. Do you have anything that you can, other than we read your briefs, that would say this was a lawyer that just fell down on his job and really undermines confidence in the penalty phase for Mr. LeBron?
I think we do. And the reason I say that, Your Honor, is with all due respect to Mr. Norgard, there was never a report that was written by Dr. D, who was his mental health expert. We don't, unfortunately, Dr. D had passed at the time that we had the post-conviction hearing.
Well, Mr. Norgard testified, though. He testified about what Dr. D told him and why he did not want to pursue that. He specifically said what Dr. D told him about the antisocial personality order and the degree to which it was manifested in the defendant floored Mr. Norgard. Isn't that correct?
That is correct. He testified to that at the evidentiary hearing in this case. The sheer volume of issues, mental health issues, that both Dr. Eisenstein and Mr. Cunningham, Dr. Cunningham, who I know you're familiar with, found in their investigation of Mr. LeBron's mental health status, if you will, I would submit to the court far outweigh Dr. D's opinion as to what he thinks that Mr.
But don't we
LeBron.
also have Dr. Dantzler in this case also? Seems to me that we have...
I believe it was Dr. Dantzler testified at the post-conviction evidentiary hearing.
And he directly refuted some of the, much of the testimony from Dr. Cunningham and Dr. Eisenstein, didn't he?
My recollection is, is that Dr. Danziger talked about a number of different issues than what Dr. Cunningham talked about.
But when you look at this case, you have Mr. Norgard talking about the fact that he consulted with Dr. Dees and got a very, as Justice Periente put it, damning report. And then didn't he also consult with Dr. McLean, or I believe that's another mental health expert on this case also?
I think Dr. Danziger was the only one that testified at the evidentiary hearing.
Right, but I'm talking about prior to trial, not at the evidentiary hearing, but prior to trial. Didn't he consult with someone else other than Dr. D?
Not that I'm aware of. Dr. D was the only one. My recollection that was referred to by Mr. Norgard at the evidentiary hearing.
I think that my recollection is that he hired another mental health expert to review the records, et cetera, and not to directly talk to the defendant, so that the state wouldn't have an opportunity to complete evaluation of the defendant, sort of implicate what Dr. Dees thought, which is the basis of the strategic decision not to present mental health because it was a double-edged sword.
I don't recall that, Justice Perry, I'm sorry. I don't recall that there was a second mental health evaluation done of Mr. LeBron.
But as he said, it wasn't really a mental health evaluation of the defendant. It was really more looking at the records and being able to put those records into evidence without having actually had an evaluation of the defendant. You don't recall that?
I don't, let me, I'm out of time, but in response to your question, Justice Quince, there was not any other mental health expert that was called other than Dr. Danziger at the evidentiary hearing. Okay. And I don't recall that there were any other reports. And I don't recall any testimony or any evidence at the hearing regarding any report by Dr. D, any records of Dr. D that would have been available for review by anyone else.
Well, but as noted, it was really the testimony of the attorney telling us what Dr. D had told him, and that discussion formed his decision not to put on a mental health expert who had examined him and would say that he had this outrageous, antisocial personality disorder.
You're correct. Yeah, I mean, the record does that. Okay. The record does show that. Thank you.
Thank you.
May it please the court, I'm Ken Notley. I represent the state of Florida. Dr. McLean was involved in the 2002 penalty phase, and that's set out and discussed in our brief, page 37 at the footnote. The bottom line, and I don't know that I need to belabor anything about this case really to any degree at all, but Mr. Norgard was very clear that the last thing he wanted was the state to have a chance to have its own mental state evaluation of this man, because he knew what they were going to find, because Dr. D told him. And that is that this man is, in Dr. D's words, the coldest antisocial personality disorder I have ever seen in my career.
And for Mr. Norgard to get that from somebody who was a defense-friendly expert, in itself is a statement.
I think we have, yes, ma'am. And Mr. Norgard was very clear about how many times he had used Dr. D. And I'm not taking a shot at anybody by saying that, but Mr. Norgard was very clear that he had used Dr. D many, 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 many times. I believe it goes back as far as 1985, that is what he said. And Dr. D is well known to me, he's well known to y'all, he was well known to Mr. Norgard, and I think it it begs the question to say that Mr. Norgard can't take that verbal report from Dr. D at face value.
I have a question just about the jury recommendation each time the case went to penalty phase was 7-5.
Yes, ma'am.
So just this bare majority. And yet it seems that Mr. Lebron was the major participant in this murder. Understanding that it's not our, because usually you say 7-5, either that means that Mr. Norgard kept on doing a very good job or only one more vote they needed to get a life recommendation. It's not that the mitigation is compelling. Was there some concern that there really were too many other people involved in this? Just from the record that you're familiar with, as to why that, we would normally see in a case like this a 12-0, 11-1 recommendation. I was just surprised with such little mental health mitigation to see the 7-5.
I think we would have seen a 12-0 if mental state mitigation had been attempted.
So what was it that was compelling about the mitigation that was presented?
I
do not know, and I would have to speculate.
Well, certainly that, let's face it, we see a lot of these cases that you come before us on a regular basis, and all of them have a different kind of factual predicate where they've come from. But this person, the defendant, came from a background that would be compelling to a lay person. That here's a person that was basically thrown out by his mother, is in reform school for the most of his youth. And although there may not be these other things, it was sort of a pitiful kind of situation. And so, the facts of the case about his background, his mother having the strip club and those kinds of things, the things he observed her involved in, those are things that sort of pull on the heartstrings of folks. It may not be a basis for a legal basis for aggravators or mitigators, but it's a sad picture to say we don't know why. It was a sad picture for a person gone awry.
And there is the kind of glitch in the case about the omission of the step of who actually pulled the trigger. That probably has some significance to it too. That's all I can say. Mr. Norgard, quite honestly, kind of pulled a rabbit out of a hat getting to 7-5. It could have gone badly for the defendant very easily. And I think the jury vote of itself, and while the proportionality is an issue that has been resolved, I think certainly the jury vote itself, not that I necessarily believe that a jury vote per se is terribly meaningful for a lot of things, but in this case, I think it certainly suggests Mr. Norgard did a pretty good job.
Why don't you, rather than just talking generalities and stuff, let's address some of the legal issues. What's the state's position on the suppression issue with regard to the vehicle in New York?
No standing, inevitable discovery, and harmless error in that order. It's a stolen vehicle. The Judge Perry's order is very clear. The vehicle was stolen. It was sitting out in front of a club. I believe the club owned by the defendant's mother. My understanding is in close proximity to a police precinct. It's somewhere in New York, and that, locations mean nothing to me up there. I don't know the lay of the land. I don't know I know it was a Chevrolet Blazer. I don't know what year or model off the top of my head, but my understanding is that the day planner with Mr. Oliver's identification in it was found under the console, and 4 shotgun shells, same make and model as used in the murder, were found inside the console. This, again, was a stolen vehicle. NYPD was not going to leave it sitting on the street. Mr. Lebron certainly has no standing to complain about a search of a vehicle that's not his when it's a stolen vehicle. And in any event, it would have been, they were arrested on arrest warrants for murder out of Florida. So it gets impounded and gets searched. It gets impounded and searched pursuant to a search warrant. But regardless of how we get there, all of that evidence gets found. With respect to the other issues, if the court has specific questions, I will, certainly, answer them to the best I can.
Well, on the mitigation, since this was tried 3 to penalty phase, I guess this is the third time. Did Mr. Norgard use a mental health expert at any of the other penalty phase?
I believe he used Dr. McLean in the 2002 proceeding.
That's what you said was in
Yes,
your
ma'am.
footnote. And what was the reason he didn't decide not to use Dr. McLean again?
That was not really fleshed out at the hearing.
Because it's really important. When something gets tried over and over, you figure that you can look at and say, well, why did this strategy, it didn't go well last time, I'm going to change my strategy. Was Mr. Norgard asked about that, whether he did anything different and why he did it, or is that just absent from the record?
He testified that I'm trying to think of the word he used because he had a pretty good phrase for it. He said he reevaluated what he had done every time in preparing for the next proceeding, and that the presentation that was put on at the penalty phase that we're on now was the result of his considered strategy based upon his assessment and evaluation and review of the prior proceedings.
And I think that's an important thing from when we're looking at deficiency, that it's the same counsel for each
Yes,
one,
ma'am.
so he's building on whatever he has
Absolutely.
decided.
He kept trying, and he kept getting the same result, which is quite honestly uncommon. I mean, usually it gets better for the state on retrials
Really?
or reproceedings. But anyway, with that said, if the court has no further questions, I would ask the court to affirm the denial of relief.
Thank you for your arguments. The next case on our docket for the day is McCoy versus State of Florida.
May it please the court, my name is Dave Davis, representing Mr. Thomas McCoy in this capital case. The case arises out of Fort Walton for a 2009 murder, in which Mr. McCoy pled guilty to it, went to the penalty phase, jury by vote 11-1 recommended death, and the judge found two aggravating factors: that at the time of the murder he had a prior conviction for an aggravated assault, and it was also cold, calculated, and premeditated. Facts in the case are bizarre. I've been doing these cases for over 35, almost 34 years, and this has got to be one of the most unusual that I've ever had, in that we have a man who's clearly severely mentally ill to the point of being psychotic. But
Well, let's just on that, because we've had in recent years the Green case, for example.
Right.
What mental health expert diagnosed Mr. McCoy as being psychotic, which is a psychiatric term of art, as opposed to severely depressed, other terms, but an actual psychotic diagnosis of psychosis?
There were two experts in this case, Dr. McLaren, who testified for the state, and Dr. Larson, who testified for the defense. Neither one found him psychotic for that diagnosis. What they did find
Okay,
is,
so just so, since you've been doing this that
Right.
long, you understand that when you're saying that someone's severely mentally ill and that they're psychotic, that we've got to stick with, and I understand these are bizarre, they're bizarre facts, doesn't mean that it's never happened, bizarre facts, but it's just the motivation showed that there was something seriously wrong with this
Right.
defendant. No question about that. But I know you're getting at that would somehow eliminate the cold
yes,
aspect of this crime. And I've read the case of the Kennedy case from 1993,
Right.
David Kennedy, in which you were
Right.
the lawyer. I see, and I think that there are differences in that case that make this a much more of a heightened planning, even if the motive was wrong, that it was definitely heightened premeditation. And you agree there's
Yes.
heightened
It was
premeditation.
calculated, it was certainly calculated, it was certainly premeditated. I have no problem with those. The coldness, as you're alluding to, certainly is
But
is
the
where I'm focusing.
coldness that we generally, in reading all the cases that we think about, is someone who is in an emotional frenzy. And Kennedy, over a period of a couple of months, the defendant became convinced that his wife had been raped by this particular person.
Well, I've
That he ended up killing, but he may have killed his wife either accidentally or on purpose.
Well, he was
And-
convicted of first-degree murder of murdering her.
Yes, well, but it was not. There was no indication of heightened planning
For her murder.
for her murder. So in this case, he's clearly planning this murder because he's
Yes.
planning it and telling people.
Absolutely right. He was planning it, it was premeditated, it was calculated, but on the day of the murder, and that's, if I can interject here, and let me just carry on, I think where you're going with this, on the day of the murder, what had happened is over the course of several years, he had had this hatred develop for these three men, Ralph King, who doesn't really figure into this case, but then Curtis Brown and Ray Jackson. And it was Ray Jackson he wanted to kill because it was Ray Jackson and Brown that had joined in this cabal to keep him from being rehired, at least in his mind, being rehired by Coke. So he calls in at least two false repair reports, one to Walmart, another to another store. They didn't really pan out. But on the day of the murder, he calls in one to Northwest Florida College about there's a broken down Coke machine at I think it was a student lounge. And as it turns out, Ray Jackson was supposed to go there and fix it. And it was clear that I think that McCoy clearly wanted Jackson to kill Jackson. I mean, his fury was towards Jackson. James Ledden had talked about him getting this way towards him. But at the last moment, Curtis Brown says, no, I'll take that repair order, and goes in there. And then McCoy says, oh, gee, it's not Ray Jackson. And then he almost on the spot changes it. And as he tells Dr. McLaren and Dr. Larson, he went into a panic attack, which is what you're looking for. This was not the man he wanted, but, oh, well, he'll do.
So wait, if he had killed Ray Jackson,
I would have a much weaker argument.
you think that because after he went in and then he realized it was Curtis Brown, he stated, now you say he went into a panic attack.
No, I'm not saying that's what he said.
He said it, but what psychiatrist says?
I think it was both Doctors Larson and McLaren both said that McCoy told him that.
That he
when
panicked.
When
but
he
what did
realized
they say about his state of mind at that time?
Well, both of them will find will find the statutory mitigator that at the time of the murder he was under the influence of extreme mental or emotional disturbance.
But your argument is that if someone at the time of murder is also under the influence of extreme emotional disturbance, they can't also act in a manner for CCP.
Well, let me say this.
And we've rejected
yes.
that.
Well, let me back up here because I know you've said that in Evans and Sexton. You both said that the facts in Evans and I think Saxton or Sexton, something like that, are kind of strange themselves. But one of the things I'm saying is the CCP and the extreme emotional disturbance are just naturally at odds with each other. And I think for you just to check it off and say, well, we've said this, is not really doesn't give honor or respect enough to the inherent conflict there. And I think if you're going to say that, you've got to say, yeah, they can peacefully coexist, but there's got to be some compelling reasons why they do in this case. Now, in this case, besides the fact that he was under the extreme emotional disturbance, it was at the time of the murder. I mean, when he says he's in a panic attack, and he says, well, he'll do, and then he kills.
But
this
I was
guy.
under the impression that the extreme mental distress was not a panic disorder on the precise moment of the shooting, but on the precise moment of the shooting, he had built up over the period of time.
Right.
This out of proportion. I guess it's almost a paranoia,
Well,
but an out of proportion anything somebody would say, he would build it into something
Right,
else.
I mean, just trivial comments.
Well, I understand, but that's what I understood that they were talking about with regard to his extreme mental illness, not that something else happened on the day when they walked into the lounge, because he left his tools, didn't he go back and forth? And,
Well,
and
yeah,
he was
yeah, well, that was one of the things that ticked him off, is that Brown had left his tool bag unattended, which became a reason to kill him.
And that was also, I mean, how does the fact that he confronts him and then shoots him 6 times, you know, emptying the gun, I mean, is that a panic? You're panicked and you shoot somebody 6 times. I can see you panicking and running, you know, you shoot somebody and run, but he stood there and shot the man 6 times.
Very quickly. He was an expert at this. He said he was proud of being able to unload that gun in 5 seconds.
So if you're an expert,
so yeah,
you can panic and
well, that's what he said. Again, we're looking at this as, I'm assuming we're all here are normal people, and we look at this as a normal person would say. And this is not a reason to kill somebody. This is really, but this guy was so depressed and he had psychotic symptoms to the point where, like you're suggesting, Justice Lewis, everything somebody said, he took the wrong way and became a justification. And so this is building up in him. 6 months before this murder, he's talking to James Ledden, and when they talk about Ray Jackson, Ledden says that McCoy's face became flushed, became vein sort of burst, were becoming pronounced, and he was just at the mere mention of the name, he goes berserk. And so on the day of the murder, he is under this extreme emotional disturbance. It's maybe persisting, but then when you have this panic attack and
you're describing what he says happened, but as Justice Quince was just saying, he places the call. It's not like at the moment he expects to see Ray Jackson, and then he sees some stranger.
Curtis Brown. He sees Curtis Brown.
But I'm saying he sees instead a young co-ed, and he had the gun already, and he doesn't know what to do, so he just sort of reflexively shoots. That's not this case.
No.
Okay, so what happens instead?
I'm sorry.
You got to give the facts in the light most favorable to the state, don't you? He knows at some point after he gets to this fake service call that it's not Ray Jackson, it's Curtis Brown, who he decides he also has a lethal hatred for.
Right.
Right. Okay. Not reasonable, but certainly his decision as to why he's going to kill him. Does he go back and he has secreted his weapon because he doesn't want to panic anybody else? Doesn't he walk in with?
No, my understanding is he had the gun with him, and that was the way I understood facts, is that he understood, and it was actually Curtis Brown that had gone out and come back.
Okay, he didn't conceal his murder weapon on the way in to commit the crime?
In the sense that he then had to go get it, I don't think so. That's not my recalling. My recalling is it was Brown that went out, came back in, and then McCoy confronted him. That was my recollection.
When did he realize, in reference to the killing of Curtis Brown, that it was going to be Curtis Brown that was showing up and not Ray?
Yeah. Well, it's when Curtis Brown shows up to fix this allegedly defective.
So what I'm asking is, and then does he just reflexively shoot? Isn't there a conversation they have?
There is, well, not much of a conversation. What happens is he sees Brown put his tool bag there, and then apparently goes outside, I guess, to his truck and comes back.
Curtis Brown. So isn't that during that time, which is not immediate? Your client is making a decision. Do I abandon my plan and start another fake call so I can get Ray Jackson? Or do I decide that this guy's good enough and I'm going to now kill him?
You're putting words in his brain. What happened, what happened, what he said, I went into a panic attack, and he says, I reprogrammed myself, and he says, he will do, or words to that effect.
Well, how can it be a panic attack when he also, it seems to me, he also indicated that I would have let him go if he had actually been nicer to me and reminded me that he had a family and all of this, and I would have let him go. How in the world is that a panic attack?
That's what he says afterwards when he's talking to these psychologists. Mm-hmm. But what he says and what is really going through his brain is, this is not the guy, but I can shoot him anyway. And there are voices in his head, these command hallucinations are saying, do it, you got the gun.
It's a good script now you're putting together about hallucinations at the time. There is no credible evidence that he was hallucinating, like in the case of the defendant Green, who shot a cow and thought, I mean, if you talk about bizarre fact patterns, right?
Right.
This is somebody that, again, was I agree there's mental illness when somebody decides they're going to kill somebody because they perceive they've offended them on some nonviolent way. It was built up over years.
Right.
And he told people days before, you're gonna see something, so much so they were convinced. I mean, this is, although it is not your classic execution-style murder in that it wasn't a murder for hire, it is a pretty aggravated case of CCP.
Well, it's a pretty aggravated case for calculated, premeditated, I agree. But when we're looking at the events around it, and looking at what's building up, and he is certainly angry, and irrational, psychotic anger he has got.
Isn't your better argument would be that because they found the statutory mitigator of extreme emotional distress, that offsets the CCP? Now, I mean, isn't that really the way that we should evaluate it? Since we allow both to be found, and this seems to be both found, and let's assume it's credible. And I would be more inclined to your argument on proportionality on that basis, but for this, the assault on the law enforcement officers when he is getting arrested. And your argument on that is he shot up in the air or something and he didn't intend to hurt them, but the judge and the evidence shows to the contrary, that he was going to go out in a blaze of glory, that he was heavily armed, that he had his gun with him, that it wasn't that he shot up in the air, that he actually shot at a trajectory that was straight, that almost got the law enforcement officers. So I think with that additional aggravator, it puts it in a different category. Now, so I'm sort of moving to proportionality.
I'll be glad to talk about
because
proportionality.
I think that, again, the answer with the CCP, and I've thought, is that you can have both, and if you have CCP, it may be weakened because you also have extreme emotional distress. And that may be the case in a single aggravator situation. Right. But this additional prior violent felony seems that it takes it out of that category.
Well,
which is a subsequent felony.
I understand. Right. The problem with that is he's still mentally ill when he goes down to Tampa. And he goes down to Tampa, and he has this idea he's going to go out in a blaze of glory, the cops are going to shoot him. And as he tells as both Drs. McLaren and Larson both say, he wanted to commit suicide, but by a cop.
He says that, but again, he was also intending he didn't care if he also injured or killed a cop by the evidence in the case. So there is an assault that he's committed. And, until the Supreme Court tells us that mentally ill individuals cannot be executed, the death penalty can be imposed lawfully on somebody that is considered to be mentally ill.
Doesn't it strike you as kind of strange that somebody who's mentally ill, not simply mentally ill, but psychotic?
Well, you keep on using the word psychotic, and I don't know if you...
Depression is a part of psychosis. I mean, there's a case I cited in there in which you recognize that depression can become psychotic.
I'm not an expert in mental illness, and you may have far more knowledge. I'm asking, we talked about this again, the working diagnosis, he saw doctors in 2006, were depression. He was put on some of these antidepressant medications. Zoloft, not an antipsychotic medication. There is no diagnosis that that was made of this defendant before or after, that at the time of the murder or the years preceding, that his working diagnosis was he was psychotic.
What I'm saying is, yes, in the sense that depression, the severe depression that he was suffering from, is a form of psychosis. And in fact, Doctors McLaren and Larson said it was severe depression with symptoms of psychosis involved. So this guy is, I mean, we use the word depression and we kind of kick it around. Well, it just means, we bounced a check, the car broke down, or, the Gators won or lost, something like that, and we all get sad. But this depression is a mind, it alters your way of thinking, the way of seeing life, which is clear here, that this man is so mentally ill in the sense that he has got this depression with these elements of psychosis. He has breaks with reality. At the time of the murder, he hears voices saying, do it, you've got the gun, let's do it. I mean, this is not a man who is just sad because he's out of work. I mean, this is a man who has seen his life over the course of 3 years when he gets off the Zoloft and he can't take it anymore, and his whole mental state is deteriorating to the point of, and I won't say insanity because he clearly wasn't insane, but he really is severely mentally ill, as to the point at the time of the murder, and then 11 days later in Tampa, he wants to go out with a blaze of glory. He wants the cops to kill him. And that's what he's talking about. And, he shoots in the direction of the cop, but this man was a trained marksman. He knew how to shoot this gun. He'd been in competition. He could have unloaded that gun in 5 seconds against this officer, but doesn't. He does it just...
Well, he's being shot at the time because he turns around with a gun. Right. So he may have been, because the U.S. Marshal didn't even know that those shots had come, but he saw him
he didn't know,
point the gun. So it may be that he was a little off because he was being shot at the same time.
Well, it may have been a little bit off, and then maybe he didn't intend to...
But that's not what the judge found. Aren't we bound by the judge's...
He was convicted of an aggravated...
Let's just try to keep it... you and me, and I know you're passionate about this and appreciate that, is that the judge in this case found that, rejected the idea that he was merely trying to be killed by the police, that he was convicted of aggravated assault, and that the way the bullets were aimed indicated an intent to harm the police officers. I'm
looking at the sentencing order right now, but I don't recall the judge saying exactly.
Let's see here. The defendant drew his pistol, discharged his weapon in the direction of the officers, and endangered the officers. Although the defendant told Dr. Larson that he aimed pistol high and intended only to provoke the officers into shooting him, the evidence of the bullet's path contradicts this claim. Instead, the evidence supports the fact the defendant intended to harm the responding officers and have the responding officers harm him. Witness testimony and evidence indicates the defendant's bullet traveled across the hotel's pool area, pierced 2 metal fence railings, and stopped after striking a vehicle. For the bullet to travel this path, it had to pass by the responding officers' bodies. So that's what, and that, again, I accepted that was, your version could be a version. The trial judge found that, and it appears there is competent substantial evidence to support that finding.
Okay, but then when we look at his mental state, and I think you need to figure in his mental state as well, that there's some evidence that he was drinking alcohol, there's a bunch of beer cans found there, on top of his own mental state. What sort of significance do we give
Well, I hate to bring up other types of cases, but we have examples of some mass murderers who are mentally ill. They go into movie theaters, they go into schools, and they have terrible reasons, but at some point, because of whatever's going on in the mind, they injure and kill multiple people or intend to. I don't, until this state or the U.S. Supreme Court says that those individuals cannot be held morally culpable, so the death penalty is imposed, I don't think this court, whose jurisprudence is governed by the U.S. Supreme Court, no matter how much I might think that's a better idea, is that we can override that in our jurisprudence.
Well, you certainly can do it under the Florida Constitution.
No, we certainly can't. The Eighth Amendment is under, since about a decade, has to be construed consistent with the United States Supreme Court.
Well, if the Supreme Court has never construed whether you can execute the mentally ill, and I don't believe they have, then there's nothing preventing you from doing that and then waiting for the Supreme Court to say whether you're correct or not. I mean, you've got that conformity requirement, but there's nothing saying that you can, under the Florida Constitution, find the mentally ill as I mentioned here, not simply mentally ill, that broad category of mental illness, but a very narrow category such as the psychotic and the severely depressed.
I don't know how you can say, I mean, there have been multiple cases out of the U.S. Supreme Court. Provenzano was one, where it talks about the status of mental health at the time of execution. And with regard to that, I mean, certainly if it applies at that stage in that fashion, I mean, mental health cannot be, under the U.S. Supreme Court jurisprudence, a basis for avoiding that penalty.
That's as to execution. Now, when you start talking conformity, you're talking,
Well,
has the
you're
Supreme Court
you're saying that you cannot execute someone who's mentally ill, and that's just not what the U.S. Supreme Court has said. I mean,
well, they said Ford versus Rainey, you can't execute the insane. I mean, that's.
Well, I understand, but you have to be at a certain level. It's not just mental illness. And you said this morning that he doesn't qualify for any definition of insanity.
No, he waived that. But I mean, if you're looking at conformity, I mean, you have taken a narrow view. It's got to be almost exactly on point, and the United States Supreme Court has never exactly on point saying you cannot.
Well, we have as recently as Carroll and Simmons and Barwick. I mean, we have, whether we're wrong and we'll be told we're wrong, have indicated that the Eighth Amendment does not. I mean, we've interpreted that way. And I guess my problem with this case is, and I've, again, you've done it far longer than I've been on this court, that I agree that he had what I would consider a mental illness, but in terms of the severity, we've had, again, and I don't know if it was Green or another case, somebody who had been institutionalized, had just been let out. This doesn't, to me, rise to the same level that you're talking about somebody that is having true hallucinations, psychosis in and out. And, it's just because you're dealing with this record, and I appreciate
True
that.
psychosis. Now, I'm kind of curious what you mean by that.
Well, I would mean that he is somebody who is, keep on talking about these hallucinations that somehow at the time of the murder, in my view, and he was under the impression that this person was the devil, and therefore he had to shoot him. That he was operating under some other notion, but instead he was operating, he knew who this guy was, and he knew why he was deciding to kill him. And I don't know where that is. It may not be the way you and I, as you say, would think about things, but for him that was a rational reason.
All right, let me put a little bit more perspective on this. One of the things that really is kind of amazing about this case, and why I cited Green, is you've got Drs. Larson and a psychologist, Dr. McLaren, who is no friend of defendants, both saying he at the time suffered from this severe emotional disturbance. I mean, this is unusual. And as you noted in Green, that this was a notable fact that both the state and defense experts are finding this middle mitigator applied, and that at the time he was having these command hallucinations to just do it. Now, what's also significant, I think, is both experts, Dr. McLaren and Dr. Larson, both felt that he should have been, at the time, should have been civilly committed. He has suffered from mental illness, however we define that, and was a danger to himself and, more significantly, obviously, to others.
Yeah, because at the time he told people he was going to kill somebody. So if it had been gone before a judge, he was a danger to other people.
Right.
That would have met that criteria.
Right, and so, but I haven't seen I don't recall any other capital case I've seen where any expert has ever said, gee, he should have been civilly committed. Even in Green, I don't know if that ever, but they are both saying this guy has got, and I kind of get the sense that you're kind of blowing off McCoy's mental illnesses, the depression, and he's not really truly psychotic. No, he has got a significant psychological problem that is bordering, and in fact, the psychological community calls depression a form of psychosis. So to say he's just merely depressed doesn't capture really, and that's why I'm saying it's more than just simply, I bounced a check, I'm sad. This is a severe, significant mental illness, a mental disease. And so what I'm saying here is that that clouds the CCP analysis, but probably more appropriately will affect the analysis you have to do on proportionality, because that clearly infects the CCP analysis, the aggravating factor, and this simply is not one of the most aggravated and least mitigated cases you have seen. And for that reason, I ask this court to reverse the trial court's judgment or sentence of death and remand for imposition of a life sentence. Thank you very much.
May it please the court, Tamara Milosevic on behalf of the state of Florida. With regards to CCP aggravator, our second issue, the state submits that this case represents an antithesis to the murder committed in panic or fit of rage. In other words, the record shows that the defendant committed this murder with cool and calm reflection. And his actions and the record indicate exactly what I just said, that this murder was committed coldly.
How does that dovetail with the Kennedy case, where after he kills his wife, he now knows he's going to go after the person he thinks raped his wife, and he, it's not, and there's time, he takes his son with him, it's not, he has time to reflect on it. He's not like he's just seeing the victim raping his wife, and he has time to determine that. In reading that case, it seemed to me that it was, why wouldn't that have been a CCP case?
Why would that be a CCP case?
Why wouldn't it have been one for the same reason that this is one? Or, can they be reconciled, I guess, is what I'm going to ask you.
In Kennedy, we had this, what happened is that defendant murdered a victim who he thought that had raped his wife, and this court found that there was a heated, domestic confrontation, that emotion was what actually led the defendant to commit that murder. He was severely emotionally disturbed because of that fact. And that case is different from our scenario, because here we didn't have any domestic, heated confrontation. There was no emotion involved in such a way. What we have here is we have defendant who planned this killing for months and days before this murder. I would like to point out that first of all, he announced his intentions to two people. He first announced to James Sledden in November of 2008, which is 6 months before the murder, that he is going to kill Ray Jackson. And he described how he's going to do it. He said that he would shoot him in the knees. When Jackson would get on the ground, he would shoot. When he would start crying and screaming, he would shoot him in the head. After that, a couple of days before the murder, he made another announcement to another colleague, Kilgore, that he had something big planned and that he might see him on CNN.
There's I think what Mr. Davis is conceding, that there's heightened premeditation.
Okay.
He's saying, and he said it would be a weaker case if it was Ray Jackson that had showed up at the college. What he's saying is that when he saw Curtis Brown, he panicked. He had a panic attack or something, and therefore, and because of that murder was not coldly done. It was more of a spontaneous decision. And so what is your, and you don't argue transferred intent, so what's your argument?
It wasn't spontaneous because, first of all, Ray Jackson was his initial target. However, the record shows that he hated Ray Jackson, our victim Curtis Brown, and Ralph King, who was the supervisor. He hated all three of them, because he blamed them. He blamed Ray Jackson over some incident when he made either Curtis Brown or Ray Jackson. We're not sure. Maybe both of them or one of them made that comment about insurance premiums and the fact that the defendant didn't have a family. So, and later, it wasn't just that one incident. So later on, in his head, he thought that three of them prevented him from regaining his employment with Coca-Cola. And there was, after that, once again, he said that he hated Ray Jackson because when he called him, Ray Jackson allegedly laughed at him because he lost his job. So what happened is that, to answer your question, when he lured the victim at the Florida State College, he waited in ambush, not an ambush, but he was waiting on the parking lot, and he was able to observe who is pulling off the highway. So he had enough time after he saw that Curtis Brown came instead of Ray Jackson. He had enough time to make his decision that Brown is the one who he is going to kill, because.
And doesn't the record reflect that he knew Curtis was there?
Exactly. He knew the car.
He came into the room, and Curtis was not there, but he knew he wasn't physically there, but he knew he was still on the premises because he had left his tools there. And so he waited
Absolutely.
for Mr. Brown to come back into the room. Is that the kind of scenario that
Absolutely.
we have here?
That's exactly the scenario, but I just wanted to finish this. So, with regards to reflection, how much time he had for cool and calm reflection. So he waited at the parking lot, and then he moved, when he saw that Curtis Brown came instead of Jackson, he moved to the entrance of the building. And from that entrance, I don't know how long he stayed there, but he, again, observed him, probably to see where he was going. So he entered the room where Coke machine was located, and he waited there. And then at one point, I don't know, maybe he went out, and then Curtis Brown came in. He left his tools there, and then at the next moment, he left the room. And at that moment, defendant came, and he was located probably behind the Coke machine, and he waited there.
Well, most of what you're saying and what we're saying comes from what Mr. McCoy told Dr. Larson and Dr. McLaren. Now, what is strange about it is, in what he told him was, he remembered feeling angry, thinking that Mr. Brown was wasting time because he had been berated about wasting time. He also mentioned seeing a tool holder, a tool bag. So it had been his practice, was not your practice, to leave the Coca-Cola tools unattended. He talked about being angry about that. He said he remembered thinking about that the victim, Mr. Brown, being a hypocrite. And at that time, he was standing in that room looking at the tool bag. He hadn't completely made up his mind. He said he could have left and I wouldn't have followed him. So the problem, what we're having here, if we're going to be deciding this CCP part based on what was in the defendant's mind at the time, it is hard to think that that scenario is a cold scenario as opposed to a product of a seriously mentally ill mind. I mean, who does that? Who does that within any range of anything? So is it because if he had killed someone because they had raped his wife, that would be, we wouldn't impose a death penalty, but because a defendant is, as Mr. Davis is arguing, and I'm just taking Mr. Davis's side just to try to understand this, that is so severely mentally ill that he decides to kill somebody because the man left his tools unattended, that person is more deserving of the death penalty?
Well, first of all, with regards to the fact that defendant said that the reason why he decided to kill Curtis Brown was because he left his bag unattended. That's all based on his self-reporting.
Well, sure, but everything you said about leaving the tools, going out, going back, isn't that all based on his self-reporting?
Yes.
Okay, so that's the problem we have, is that if we talk about the coldness, we know, again, it was cold as to Mr. Jackson, but as to the motivation at the time of this murder for Curtis Brown, what else do we have to hang our hat on other than what the reporting was?
Well, the fact is that he didn't decide to kill Curtis Brown when he saw that he left his bag. That's what I'm trying to point out here. He made the decision before that happened at the parking lot. So my point is that we're looking at cool and calm reflection to find the coldness element of CCP. So the case you mentioned, Kennedy, somehow defendant attempts to to find a parallel between these two cases where we have in Kennedy like domestic heated emotions, and this case where we have like two former colleagues, and we have who work together, and defendant simply thought that he has been mistreated, and he decides to kill his coworker. So, to answer your question, again, he didn't make this decision when he saw this bag unattended, and then he went into some kind of a rage, and he just killed him as a passion or some sort of frenzied attack. What happened here is that he made this decision, I say again, at the parking lot. So he had enough time to observe Curtis Brown coming inside the building, and then waiting him in the ambush. That's what happened here.
It sounds to me like what
I'm
you're
sorry?
saying is he made his decision, and these other actions, him leaving the bag, the tools in the room, his not begging and telling him about his wife and family, were really justifications, that he had already made the decision, and that these subsequent things were really justifications for the decision he had already made.
He made a decision. As I said, like the point is that he calmly reflected what he's gonna do, who he's gonna kill, and then he acted on his plans. That's what happened here.
My concern in looking at this case, with the argument that he was so mentally enraged that he lost it and did these things, I tried to compare this case to these cases we read about where someone at work is mistreated, at least in his or her view, and goes home, comes back with a gun, and just kills everyone in the workplace. I think they call it going postal. I think what would instigate such action exists here in the fact that Mr. McCoy thought that he was being mistreated by his co-workers. The difference here, and this is kind of a friendly question to you, the difference here, I think, is that he didn't just go back home and pick up a gun and went back to his workplace and started killing people. That would give more credence to this mental enragement theory. Here, he actually went home, planned these things, tried on 3 different times.
Yeah.
Well, actually,
third time he was successful.
He did it at the Walmart first and showed up, and there were too many people around, and they went to the car wash.
Exactly.
And then the next day, that's when he went to the college.
Mm-hmm.
And so it was well plotted, and it was limited only to the people that he was angry at. That, in a sense, dispels my concern about the mental enragement argument that's being made here today. I mean, had he gone back into the Coca-Cola plant and just started killing anyone he saw.
Exactly, and also that's exactly what happened. He had his targets, and he made his decision, and he acted on his plan on 2 occasions. The only thing is that on these 2 occasions, in Walmart and Carly's Car Care, he just decided to postpone the killing. First time because there were too many people around. First time he followed Ray Jackson. He followed him, waited there, followed him, but then when he saw people around, he decided that he's going to postpone his action because there were too many people around.
Had he gone into the Walmart that day and shot the victim in this case, and then continued to shoot anyone else at the Walmart that he saw in the vicinity, that obviously would have added some credence to the theory that he was so mentally enraged.
Mentally ill, and that he acted in a fit of rage because he wouldn't be able to resist the impulse to kill him.
But there was some
exactly.
rationality in his actions.
There was rationality, and the fact that he decided that he made a clear decision. I'm not going to do it now. It's for whatever reason. There's too many people around, even though he said that he didn't want to hurt anyone, but most probably the fact is that he didn't want to be caught. And then he leaves the place. The day before the murder, he makes another fake service call at this place called Carly's Car Care because he knew that that was the region that Ray Jackson and his co-workers cover. However, the only reason why nobody showed up is because Ray Jackson knew that there was no Coke machine there. So his second attempt was unsuccessful, and then tomorrow when he made third phone call, he knew what he was doing. He made he gave instructions, detailed instructions where those Coke machines were located, what happened. So that absolutely shows what you just said.
In terms of painting a picture of this defendant, he was left Coca-Cola voluntarily in 2006.
In June of 2006.
These murders occurred in 2009.
Yes.
And as Justice Labarga was saying, there was a period of planning closer to 2009. But he, in between 2006 and 2009, although his life wasn't going great, what does the record reflect about how he was functioning in those 3 years, as far as was he isolated, never saw anybody, Well, he wasn't isolated. First of all, he resigned from Coca-Cola. Right.
And just one more point.
I think I said he left.
So when there was no indication in his work record or his military record that he had any mental health issues. I just wanted you to
Right. In other words, he wasn't let go of Coca-Cola because he was acting erratically.
No, he wasn't let go. He resigned, and the record reflects that, and that's what Ralph King, his supervisor, testified, that Coca-Cola company had a policy until 2005 that they were paying their employees for the costs they would occur going to and from work. So that policy changed in 2005. And
I understand
okay.
that. But what I want to know is, after he left Coca-Cola, is it a portrait of what is the portrait of this defendant? Was he living on his own? Was he working at all?
He was living on his own. He wasn't married.
Which was one of the other sources.
He was attempting to develop his private business.
And what was that private business in?
I'm not sure what he was doing, but it was something related to his technician, to his profession as a service technician.
So he had the ability, he had technical skills.
Absolutely. So I think that's what he was doing, and his truck was also like the technician's truck. He had, I don't know what was written on the truck. I don't have that.
Wasn't it also after his resignation from Coke that he actually had this diagnosis of being of severe depression, and was he diagnosed as bipolar also? Didn't this occur after his resignation?
He was diagnosed with depression first time in 2006.
After the resignation.
I'm not sure whether it was after or before, because I didn't have a month when the diagnosis was established.
The diagnosis, I thought, was in November and December. When did he resign?
He resigned in June of 2006.
Okay.
And he was diagnosed with depression and bipolar disorder in 2006.
And who was that? Was that by a general practitioner?
Exactly my point. He was diagnosed by Dr. Patel, who was general practitioner in 2006 for bipolar disorder, and he was diagnosed.
Did Dr. Patel testify?
No. So
there's no evidence that anyone recommended that he seek psychiatric treatment or be committed?
He never testified. Dr. Larson was the one who testified based on the medical records that these previous doctors made.
With everything that we have, if this CCP, and we have two experts, including the state, saying he's under extreme emotional distress, you only had that. Do you agree that the significance in this case of the additional prior violent felony aggravator takes this to a different level? I mean, do you think you'd have a harder case if this was the CCP, extreme emotional distress, just of this, not undermining it, but of this incident?
Well, just to make a point, with regards to mental mitigation under extreme mental or emotional disturbance, the trial court gave it only a moderate weight. So it wasn't it didn't assign it great weight. It was a moderate weight. That's what what I'm trying to point out. He had mental health issues.
Still pretty unusual for the state's expert to agree that this person was under extreme emotional disturbance and should have been civilly committed at the before this murder based on what was going on in his life.
And based on the fact that the defendant said, based on the history of this case, that he was announcing that he's going to commit a murder, and that there was a police investigation based on the first.
Well, they didn't do any. They said, "Don't go. We can do a well visit, but don't. If you go there, you might anger him." Isn't that what what was said by the police agency?
When you're referring to the first time when?
Well, there were two times that
Yes.
the people were concerned enough.
Yes.
Okay, but what I'm asking you about this, because I think the emotional distress, the mental mitigator is certainly there. I'm going to proportionality now. What puts this to me in a different category is the fact that there was aggravated assault of law enforcement. Would you agree that without that we'd have perhaps more difficulty finding this to be a proportionate penalty?
Well, we have like two serious aggravators here.
I think I do. Okay.
Yes. So the fact is that we have this prior violent felony, which was given great weight. And as I said, this mental health mitigator was only assigned a moderate weight. So we have to look at the totality of what the trial court found here. So we have two very serious aggravators, CCP and prior violent felony. And we have this mental mitigation. And don't forget that the capacity mitigator wasn't found. So we only have extreme mental and emotional disturbance, which was...
He was how old?
He was in his 40s. He was born in 1966.
So, and was there a history? Did he have a criminal history?
No, he didn't have a...
So was that
mitigator too? Exactly, yes.
So, I mean, again, this isn't your run-of-the-mill death penalty case. There are some concerns here that we do have a seriously mentally ill person, but that was still capable of living on his own, living a, quote, normal life to all, being able to, wasn't letting himself go physically, and made, as you have pointed out, a calculated decision to murder one person, and when that person wasn't there, made a further calculated decision to kill the ultimate victim.
And just one more thing. Before 2006,
and by the way, and then he could have just stood there and waited to be picked up by police. Instead, he escaped.
Exactly.
He spends 11 days secreting himself, heavily armed, and intending to go out in a blaze of glory.
Absolutely. And his report that he wasn't intending to hurt police officers is absolutely not inconsistent with ballistics report and with the evidence in this case. He spent 11 days in Tampa, heavily armed. The police, after the arrest, the police found hundreds of rounds of ammunition and guns. So he was definitely prepared for confrontation with the police, and that's what he did after they tried to arrest him.
The sentencing order said he's in military reserve, right?
Yes, he was in military.
Is there anything in the record that indicates
No.
whether he was called out or served in any way in that
No.
capacity
No.
from the time that he left Coca-Cola up until the time of the murder?
Well, his military record shows that he was honorably discharged, and there was no indication in the record that he had any mental health issues.
But there's no activity as a reservist between 2006 and 2009?
I don't know. I don't think the record has any indication about that. And also, his work record also didn't indicate in any way that he had any trouble at work. He was a good employee. That's what the testimony from his supervisor. That's what his supervisor testified. no issues with the defendant, good employee, no issues between defendant and other coworkers, and no indication of any mental health or psychiatric problems.
Had he ever served in active combat duty?
I'm sorry?
Did he ever serve in active combat duty overseas?
I don't think so, but the record does. I don't know. The record doesn't say.
How long was he in Tampa?
I'm sorry?
How long was he in Tampa at the hotel
How long he was in Tampa?
after the murder?
11 days.
11 days. Did he have any relations in Tampa? Any family? What was his connection with Tampa? Why did he choose
He,
Tampa?
according to what the defendant said, is that after he committed the murder, he decided to leave. So he didn't have, I think, the plan, exact plan, like why he wanted to go to Tampa. He just decided on his way out of the building, and while he was getting into the car, that he just decided he would go to Tampa. And he dropped off his belongings, his cell phone, repeating his truck, and he just entered the vehicle and headed to Tampa.
On his way to Tampa, he did spray paint the advertisement on his truck.
Yes,
so that he wouldn't be detected.
So he wouldn't be detected, exactly. He wanted to conceal his appearance. And
So he didn't really want to go out and blaze the glory.
No.
Not just then.
So he checked in the hotel, and he waited there.
He used his name at the hotel?
I'm sorry?
He used his real name at the hotel?
Yes. I think, actually, I'm not 100% sure. I'm not sure.
But he really was, I mean, it's pretty clear, and I don't think anyone disputes this, that he didn't think he was going to continue to live. I mean, however this was going to end, it wasn't going to end good for him, which is what he wanted. He wanted to be killed, and it's called, colloquial suicide by cop. But I don't know, again, I don't think any of that helps his case as far as not making it a death penalty case. But, I mean, clearly if he had wanted to leave, he could have gone over the border into another state or taken off, and he didn't do that.
And why would he drop off his cell phone? Why would he repaint his truck? He could have just
Well, what did he say about why he decided to go to the Holiday Inn and get a really nice room?
Well, I don't remember why he...
I thought it was something that, he figured he has this few days, he might as well live it up.
I don't remember why he checked in, particularly in Holiday Inn. I'm not sure. If the court doesn't have any more questions, I would like this court to affirm the conviction and the sentence of that.
Thank you. Rebuttal?
Thank you.
When I first looked at this case, I had some real questions whether I could, with a straight face, argue CCP, because I'm hearing the same problems I had when I looked at it. But when you look at the definition of CCP that this court says, in order to establish the CCP aggravator, the evidence must show the killing was the product of cool and calm reflection, and not an act prompted by emotional frenzy, panic, or fit of rage. And that's what prompted me to argue this thing.
Well, again, going back to what I was asking earlier, had he gone home, let's say they said something he did not like that particular day, he just had enough, went to his car, got his gun, and came back to the Coca-Cola plant and started killing people, including his targets, then I could see that fit of rage that you're talking about. But we're talking about someone who made 3 different attempts to do the killing here.
You're saying then that if he directs his fit of rage towards a particular person, that's not a fit of rage?
Well, no. He had time to reflect, time to think about it, time to plan it, time to do all these things, time to show up at a Walmart and see where there are too many people around. Better not do it here.
Well, that was his fit of rage. That was his idea as to Ray Jackson. I mean, that was clearly who he wanted to kill, was Ray Jackson.
The notion of a fit of rage, it seems to me, you use that terminology, seems to be something that doesn't involve this extended period of time and planning and trying and then trying again and then succeeding.
And you're
that's
absolutely
not a fit. That's not a fit.
I'm sorry.
I'm just saying that's not a fit, is it?
Well, that's certainly calculated and premeditated, but the fit of rage is what we see here. You've got the panic attack. You've got the man.
Look, people, the the murders that we deal with, most of them involve some rage and anger. I mean, that goes, now, not all of them, but that's part of it. And a lot of them that have CCP, there's some anger involved, okay?
Yeah.
There's no question about it. And so I just don't, I don't see how that this, given the circumstances here of where it gets, the victim that shows up, it's not the one he had in mind, but he keeps going. He keeps going. It's not, and this notion that is a panic attack, you know, people, when they're carrying out a crime like this, they are in a state of excitement. There's no question about it. You
Well, I
can't,
think there is a question
unless
about
unless you're a total.
That's what the CCP is the cold execution style killing. And
Well,
that's what
This
you said.
This was an execution-style killing. He called him there, it seems to me, and I don't see how you can put this in the category of anything other than an execution. He called to bring someone there to have him killed. Not exactly the right person shows up, but someone that he decides over some period of time he has an opportunity to further reflect and to follow this guy in and to carry out his plan to execute someone he doesn't like.
You're absolutely right. It was clearly a premeditated murder. But was it cold, as this court is? It was cold in the sense of being an execution. No, he was under a fit of anger. And yes, they may have it. But when you start talking CCP, you're talking about the coldness that you are going to deliberately kill.
Let me see if I can capture what you're really trying to convey here is that 3-year buildup from 2006 until the day of the murder, that may well be the cold calculated. But on the day that this happened, that it was a fit for this particular individual. That's what you're saying.
I think that captures, but I think the underlying emotional disturbance.
Well, I understand, but I mean,
I think that's what you're suggesting. This 3-year.
Yeah, that buildup that may have been there had he carried it out. But I think you're trying to say what Justice Labarga is conveying, that this one is more similar to the fellow who leaves work and goes back immediately, because this decision was made on the spot, just spontaneously and out of anger. That seems to me what you and you're saying that should be considered to not contain the cold element.
Yeah, I think that his mental illness, his extraordinary mental illness, has reflected in his the middle mitigation, and the fact that he was also extraordinarily depressed takes it out of that outright rage. Because
I think that's where you go, sort of lose it there.
Well, okay.
I mean, it just seems to me.
Well, I you know what and I apologize, I'm going over time, but you know what I'm hearing here is you're looking at it as rational people, and you can't do that. You got to look at it in his mind. This guy is one step short of being insane, and he's very, very mentally upset or dangerous.
Would your argument be the same if he'd killed Jackson?
That'd be a much weaker argument.
But weren't Jackson and King and Brown interchangeable parts? He just said that whoever showed up would do. I mean,
I think he's clear that. I don't know if they're interchangeable.
I mean, in his mind.
Well, I think, but he certainly was. The intention was he was going after Ray Jackson, and only when Brown shows up, then he makes that reprogramming. So, interchangeable. I think his anger is really directed against Jackson. Thank you very much.
Thank you for your arguments. Court is adjourned.
There you go. We'll have to wait and see what they say.